I'm Belinda Lee of Jiangqun Intellectual Property Group. Today I would like to briefly introduce third-party pre-issuance submissions. Pre-issuance submissions provide a way for a third party to submit potential prior art to the USPTO during the prosecution of a patent application. After the American Invents Act, the old rules on third-party submissions have been replaced by a new pre-issuance submission program, and the new submission program presents certain advantages. For example, under the new law, the window of submission is extended. In other words, the third party is provided with more time to search for relevant prior art documents. In this timing example, the pre-issuance submission can now be filed 24 months after the application was filed. Actually, depending on the timing of the first office action and the notice of allowance, the submission date can be even later. However, before the AIA, the latest possible date to file the submission was 20 months after the application was filed. Also, under the new law, the scope of information that may be submitted is broader. Now the submitted information may include any patents, published patent applications, or other printed publications of potential relevance to the examination of the application. In other words, documents that are not prior art in the sense of 102 and 103 may also be submitted. Further, the third party may now submit a concise description to explain the relevance of the submitted documents. A submission of any explanation in any form was not allowed in the past. This requirement can be very useful, especially the concise description can guide the examiner into rejecting the competitor's application. There are other advantages associated with the third-party pre-issuance submissions. For example, the submissions can now be made anonymously, which means the submitter can avoid being retaliated by the competitor. Further, it creates no estoppel, and the burden of proof of unpatentability is much lower than that in litigation. And since the fee for the submission is only $180 per 10 documents, it is an inexpensive means to eliminate a competitor's problematic patents. However, the third party shall also be aware that if the submissions fail to convince the examiner, it may be more difficult to challenge the patent using similar bases in the future. So the third party may need to evaluate whether to use the best prior art at this stage of the patent process. The USPTO recently published the statistics of the filings of pre-issuance submissions under the AIA. As we can see, on the average, there are about 70 to 80 submissions each month. And these numbers strongly suggest that this program is actively being used. For any further question, please contact our office.